This is Eye on Bankruptcy, brought to you by the American Bankruptcy Institute.
Welcome to the November episode of Eye on Bankruptcy, a monthly discussion and analysis of recent cases in the bankruptcy world produced by the American Bankruptcy Institute. I'm Charles Tabb. I'm the Mildred Van Voorhis Jones Chair in Law at the University of Illinois College of Law, and also am of counsel with Foley and Lardner in Chicago. In the spring of 2014, I was the resident scholar for the ABI, and I'm your host for Eye on Bankruptcy. Today we're very fortunate to welcome two distinguished guests, the Honorable Michelle Harner, United States Bankruptcy Judge for the District of Maryland, and Eric Madden, a partner with the Dallas office of Reid, Collins, and Tsai. Before moving to the bench in 2017, Judge Harner was the Francis King Carey Professor of Law and Director of the Business Law Program at the University of Maryland Francis King Carey School of Law. Prior to joining the Maryland faculty in 2009, Professor Harner taught at the University of Nebraska College of Law, where she was twice voted Professor of the Year, a partner at Jones Day, where her practice focused primarily on corporate restructuring and bankruptcy law, and a law clerk to the Honorable William T. Bodeau of the U.S. Bankruptcy Court for the Northern District of Ohio. She graduated with honors from Boston College, summa cum laude, first in her class in Order of the Coif from the Ohio State University Moritz College of Law. She was also executive editor of the Ohio State University Law Journal. Professor Harner was the reporter for the ABI Commission to study the reform of Chapter 11 and now serves on ABI's Board of Directors. Eric Madden is a partner in the Dallas office of Reid, Collins, and Tsai. His practice is focused on complex business and insolvency-related litigation. He has represented trustees, receivers, creditor committees, bondholder committees, and defrauded investors in a number of major cases throughout the country. These cases often involve Ponzi schemes, financial fraud, or significant fraudulent transfers. His work has earned the recognition and respect of his peers, including several listings in Best Lawyers in America, Super Lawyers, and Rising Star. Eric has served in leadership positions with several organizations, including as programming co-chair of the ABA Bankruptcy and Insolvency Litigation Committee, co-chair of the ABI Commercial Fraud Committee, and co-chair of the ABI Bankruptcy Litigation Committee. Eric earned his law degree with the highest honors from the University of Kansas, where he was editor of the Law Review. He also earned his undergraduate degree from Kansas and was inducted into Phi Beta Kappa. Today we will be discussing 9 cases which we have taken from Rochelle's Daily Wire, available on www.abi.org. Our discussion today will cover several new cases involving interpretations of the scope of the automatic stay, Ponzi schemes, the scope of the mere conduit defense to fraudulent transfers, whether you can modify a mortgage on mixed-use properties, and other topics. We also will discuss cases on executory contracts, standing to extend the dischargeability deadline, and the continued controversy over the treatment of IRAs in bankruptcy. And finally, we'll tee up the question of trademark licenses in bankruptcy in the Tempnology case, on which recently the Supreme Court granted cert. All right, let's now turn in detail to discuss our 9 topics for the day. All right. So first up of our topics is the very intriguing question, which only comes up all the time, of whether it's a violation of the automatic stay for a creditor to do nothing. This question comes up most frequently in the scenario where a debtor is in default on a car loan. The secured party, as is their right under state law, repossesses the car. Debtor then files bankruptcy, often for this express purpose of getting their car back, says to the secured party, "Give me my car back." Secured party in that situation often responds, sort of saying, "Well, why do you say your car? We're rightfully in possession of the car." Then the secured party say, "Well, as long as you give us adequate protection, in particular, give us proof of insurance, we'll give you back the car." At which point, the debtor runs to the court, says this is an outrage, they're violating the estate, this is an act to exercise control over property of the estate. I want you to find the secured party in violation of the estate. I want you to order them to turn over the property and sanction them for violating the estate. We're going to look at two cases that address this sort of fundamental threshold question of whether it is or is not a violation of the state to do nothing. Both the cases we're going to look at today diverge from the majority view. The majority view, of course, is that it can be a state violation, but the cases we're going to look at suggest otherwise, and each, as we'll discuss, adopts the reasoning that it's not an act if you don't do anything. It'll be very interesting to see, and we'll perhaps speculate on whether this issue will ever come before the court, the Supreme Court, because the circuits definitely are split on this topic. We'll start then with our first case, a case out of the District of New Jersey. And in that case, the court held, this is the case of Denby Patterson versus New to You Auto World, one of my favorite names, NU2U. They said in this classic car repo scenario that the secured party had not violated the stay and should not be sanctioned. Then our second case will be not as typical an issue, but it raises the inaction question. 10th Circuit, following that circuit's Cowan decision, said there was no stay violation when a lien arose by operation of law post-petition. So we'll start with you, Michelle, and get us just going. With regard to especially the car cases, but this fundamental question of is it a stay violation for which the secured party should be sanctioned for not just saying as soon as the debtor files a 13 and says give me my car back, they say here are the keys. What's the majority view and what's the reasoning that supports that?
So it's interesting. The majority view right now, at least as the court in Denby-Peterson discusses it, is followed by the 2nd, the 7th, the 8th, and the 9th circuits. And they really look at section 362A3, which, as you know, talks about an act to obtain possession or an act to exercise control. And they say, you know what, that last phrase, an act to exercise control, wasn't in the statute until 1984. That change must mean something. We think it means Congress wanted to broaden the scope of the stay. And when you read that in conjunction with 542A, what it means is if a creditor is holding property that qualifies for turnover under 542A, they must immediately and automatically give it back. And if you don't, you violate the stay. So
you're violating 362A3.
A3. So that's somewhat where the majority seems to fall, reading the language, the amendment, and 542A somewhat together.
But then we have this minority view, which says not so fast. That just can't be, as illustrated by Denby. What is the reasoning for those cases?
So just as you can follow the majority reasoning, you can follow the minority as well. And here you have really the 10th Circuit being out in front on this as the primary proponent, but the DC Circuit follows it as well. And they say, okay, we understand there was an amendment in 1984, but let's look at the language. It's prospective, right? 362A3, saying focus there for a second, looks forward. It talks about an act to do something. So if all the creditor is doing is maintaining the status quo, it's not acting. And interestingly, it actually cites the Denby-Peterson case, cites one of your colleagues, Professor Brubaker, and one of his articles where he's talking about the 1984 amendment and says what it was maybe intending to do was get non-possessory conduct that interfered with the estate's rights. And so
when you're taking an act.
Right. Exactly. So, you know, the court really stays, I think, in its view, true to the language of 362A3 and says if you're looking just at the stay, we need an affirmative act, right? Think about the definition of act, an affirmative act. And then, yes, you have 542A and we have 361 and 363, which talk about adequate protection, but they're each independent sections of the code that balance the rights of creditors and debtors appropriately.
Let's follow up on that point, because that's an interesting one that I know some of the cases in the minority view season on, and I know Professor Brubaker talked about as well. If you think about, I mean, looking at it from the perspective of the secured party, and sort of think about, go back to first year property, the bundle of sticks idea. At the time of bankruptcy, the possessory stick in the bundle was not the debtor's. And if you go look at the turnover statute in 542, it says you have to turn over property of the estate, and property the trustee can use, sell, or lease.
Right.
And you go look at 363, and it talks about adequate protection. And so you're like, the secured party is saying the car, it wasn't just the debtor's car. It was a car in which the debtor had ownership and we had the right to possession. And we're simply maintaining the status quo. If you trace the statute through to 542, it says basically that we have to get adequate protection. In other words, it's not automatic. Well, sort of following on that, there's a couple of Supreme Court cases that might potentially be relevant here. One is Whiting Pools, which of course was the foundational case. Is it ever possible under any circumstances for turnover to be required of a rightfully repossessing secured party, in that case the IRS? And then the Citizens Bank versus Strumpf case, which was of course the freezing a bank account. You can't set off, but can you just freeze it? You violate the stay if you just freeze it. Do you think those cases are relevant to this issue? How if so, how? What do they tell us?
So I think the Whiting Pools case is somewhat the starting point for these cases, because Justice Blackmun in that case clearly articulated the proposition that pre-petition possession can come back into the estate, right? But they didn't get into stay violations. They basically looked at those facts where the IRS has seized Whiting Pools' tangible assets. The next day, Whiting Pools files and seeks turnover, and the court says there's still an interest there.
Yes.
So now that gets to your bundle of property sticks, right? Who has what interest? And I think in the car cases, it's important to look to state law.
Yes.
And in many states, right, if they're following Section 9506 of the UCC, there's that right to redemption.
Right.
And that was a little bit of an issue here, although the
Right.
court found that under New Jersey
Right.
law, the particular waiver wasn't relevant.
Right.
But so there's some interest that comes
Right.
into the estate, which again, Justice Blackmun really emphasized the broad nature of 541. So we've got at least a beneficial interest coming into the estate. But I don't think it answers the question. So then maybe that gets us to citizens,
Well, and indeed,
right?
I mean, if I can just interject,
Sure.
I mean, in Whiting Pools, I mean, and so you have lots of cases basically talk about the stuff, talk about, Whiting Pools basically says that 542 gives the estate a possessory interest it didn't have before. But again, the secured party is, in all these cases, is never saying, we will never give you the property. They're saying, if we get adequate protection, we'll
Right.
give you the property. And in Whiting Pools, before turnover was ordered, the court found that adequate protection was on the table. It had
Right.
been offered and it was in fact adequate. So what one could argue, there's not really any precedent from that case. Well, what about the Strumpf case?
So I think the cases you've identified are great building blocks to get us to where the minority at least is on
Yes.
the 362A3 cases. Because if you then look at Justice Scalia's decision in Citizens, he starts to talk about the administrative freeze, right?
Right.
And he talks about how different sections of the code do different things, right? So
Right.
you have 362, but then you have 553 that allows a set off.
Right.
And what the bank did here wasn't actually set off,
Right.
but it preserved that
Right.
right to ask for authority to set off. So
Right.
you start to see the building blocks that lead you to where the minority is saying, wait, we understand everyone's rights,
Right.
let's slow down
Right.
and let everyone ask for the protection the code gives them, which is, I think, where the 10th Circuit falls.
Right, because the 10th Circuit clearly says we're just talking about preserving the status quo. We're not effecting any final settlement of the rights or whatever. Well, let me ask you this, Michelle, and then I want to ask Eric about the Garcia case. If we, in cases following the majority view, what's the concern and risk for the secured party in
So-
that situation?
So again, I understand the reasoning of the courts that followed the majority, but I think from from a secured creditor's perspective, you're somewhat put in a position where you're not quite sure how to protect your interests, right? And you're almost the benefit of your bargain, what you bargained for or thought you were bargaining for, is really unsettled,
Right.
under the majority approach, because you're put in a very defensive posture as opposed to under the minority, where at least you can act to preserve. And I guess the one other thing I would note about both positions, the majority and the minority, I think they're concerned with wrongful conduct by the secured creditor, right? And that's
Right.
really what they're looking for. And the minority even says, if you have someone who refuses to abide by a court's turnover,
Absolutely.
the courts actually should then use 105 and
Absolutely.
sanction, and we can take care of that. And they cite the
course.
Cowan case, or the
Yes.
Cowan, I'm not sure how you say it, from the
Ye-
10th Circuit.
yes.
So no one's suggesting secured creditors should get away with anything, or be able to withhold wrongfully.
Right.
But it's really a matter of what procedural path is best at balancing the rights
At
of
balance. And definitely you're right. The minority courts always talk about this as the best balance.
Yeah.
Well, let's shift gears a little bit, because this all falls under the inaction as not being a violation. But Eric, you get a case like Garcia where the facts are very different. What happened exactly in that case, and what was the trustee upset about? And sort of, if we follow a case like Garcia, what does that do to the rights of all the other unsecured creditors?
Right. So the trustee in that case was upset about potential stay violation. In Garcia, the Chapter 13 debtor, before filing bankruptcy, had slipped on a floor mat at work and was injured. She collected workers' compensation benefits from her employer and then filed the Chapter 13 case. During the Chapter 13 case then, she asserted a claim against the company that had installed the floor mat and eventually settled that claim. And it was at that point then that Tyson asserted a subrogation lien on the settlement proceeds to recoup the money that it had paid for the workers' compensation benefits. The trustee, however, argued that that was a stay violation because it violated Section 362A4. That lien arose by operation of the state workers' compensation statute,
The
automatically,
subrogation lien.
the subrogation lien,
Right.
without any act by the creditor. But the trustee argued, nonetheless, that violated 362A4.
10th Circuit, though, held what?
10th Circuit said no, it does not. The 10th Circuit followed its decision in the Cowan case, which we mentioned earlier, which is a 2017 decision, looking not at 362A4, but this A3 provision we just talked about in the New Jersey case. And in Cowan, the 10th Circuit looked to the plain meaning of the word any act, and looked at the dictionary definition and said, well, act means to do something. And here the creditor hasn't done something, so there's no stay violation. And so the 10th Circuit, following Cowan, held that there was no stay violation here and Tyson's lien was valid.
What concern, as a policy matter, I mean, what concerns follow from a holding like we have in the Garcia case? I mean, is this really fair to the other creditors? I mean, you can't go out and get a lien on other stuff, but if the lien just arises, so they not only said there was not a stay violation, they said the lien is valid and enforceable.
Right.
Like, good for you, Tysons. You're now better than everybody else because they're just. Is that okay, or is that just something the statute just doesn't address? I mean, how does this come out?
It does seem unfair, and clearly that's why the trustee in Garcia challenged the lien in the first place. It's also something that when you look at the underlying decision in the bankruptcy court in Garcia, a decision by Judge Nugent, it's something that seemed to bother him as well.
Sure.
He pointed out in his decision that he had reached an opposite conclusion, that inaction can be a stay violation in two prior decisions. And so he seemed to sort of reluctantly follow the Cowan decision. He said, I'm duty-bound to follow this, and so I will, and so there's no stay violation. And
But it bothers me.
Sent the parties on their way for a direct appeal to
Yeah.
the 10th Circuit.
Well, let me ask both of you this, and I'll start with you, Eric. It seems that this is the broader issue of the scope of 362A, the inaction as a stay violation comes up in A3 and A4. This certainly could end up in the Supreme Court, one would think. It's a clear circuit split, a very important practical issue. So getting out our crystal balls, Eric, what do you think would happen if this went to the Supreme Court? Would they side with the majority and say it is a stay violation, you should get sanctioned? You think they would side with the minority, say an act? I don't see an act, no stay violation. What?
Well, if you're going to twist my arm and make me
I
speculate...
am going to twist your arm. That's my job.
I would speculate that the court would probably adopt the minority view and
Tell me
find
why.
that inaction is not a stay violation. The reason is pretty simple. The minority view takes more of a textual approach to interpreting the statute and looking at the plain meaning of words, and many of the current justices adopt that view. Justice Kagan, who's viewed as a more liberal member of the court, has said this is a textualist court. So I think the court's likely to take a plain meaning approach and say act means to do something. I also think that some members of the court may be concerned about the implications of the majority view on business interests and creditor interests because of the uncertainty that you haven't really done anything and now you're potentially in violation of the stay. And so I think the court overall will adopt minority view.
Judge Harner, what do you think?
So I absolutely agree with Eric and would come out the same way on my prediction,
Yeah.
although my predictions are wrong all the time, so I don't know.
Well, it's
But
especially hard to forecast how the Supreme Court's going to decide.
It is, and the one thing I will say is, one reason I think they would come out that way, because what bothered Judge Nugent, and what bothers, I think, many of us with something like the Garcia case and the unfairness to the other creditors, isn't because of a defect in 362, right? It's really a defect in how the code addresses this kind of,
Yes.
of statutory lien.
Right.
And it's interesting because the code addresses consensual, judicial, and statutory liens in various places, but not this particular
It does,
problem.
and I mean, we could talk about 552, but I don't know that it really squarely is on point here. So we do have a gap. Well, let's move on to another very important, very common. This is we're living in Ponzi world these days, and over the past decades, courts in many jurisdictions have developed a whole series of Ponzi scheme presumptions. What we're going to deal with today, a case of Pergament versus Marina District Development Company, a case out of the Eastern District of New York, which was discussed on October 19th in Rochelle's Daily Wire, really raises the question, how far does the Ponzi scheme presumption go? Specifically, whether an innocent transferee who was not a participant in the scheme, they were not an investor, it was just someone else, does it apply to them? And in that case, facing a motion to dismiss, the court held, perhaps surprisingly, that it did potentially expose them to risk. What had happened in that case is, very quickly to get it on the table, the bad guy, over the period he was running a series of Ponzi-like schemes, gambled regularly at this casino. Apparently he was not an excellent gambler. He lost about $4.7 million. The trustee then sues the casino, says, give me that money back. I want to claw that back. When the debtor was gambling there, when he's investing, if you will, that money, the idea was he's going to win and pay off the investors that he's defrauded. So it's in furtherance of the scheme. The casino, of course, goes ballistic over this, moves to dismiss under 12b-6 with regard to both the actual fraud and the constructive fraud claims. So, Eric, how does this come out with actual fraud, constructive? What were the holdings with this?
Okay. Well, so do you want to talk about the presumptions first, or go right to the holdings?
Let's first just get it for our viewers. Tell them what the Ponzi scheme presumptions are,
Yeah.
and how they're used. Sort of what the mechanics of how that comes into play.
Yeah, so the Ponzi presumptions are simply evidentiary presumptions that courts use or may use when a trustee or receiver is seeking to claw back transfers out of a Ponzi scheme as fraudulent transfers or conveyances. There are three standard Ponzi presumptions. The first and most common one is that transfers made in furtherance of a Ponzi scheme are presumed to be with actual intent to hinder or delay fraud creditors. The rationale is that a Ponzi scheme is a pyramid scheme. It can't last forever, and at some point the pool of new investors will run dry and the scheme will collapse. The fraudster surely knows that, and so every transfer in furtherance of the scheme is with intent to defraud.
Trying to keep it propped up.
Right.
Yeah.
Second presumption is related to insolvency, and that is that a Ponzi scheme fraudster is presumed to be insolvent from the inception of the Ponzi scheme.
Indeed, that dates from the very first, the Ponzi case itself,
Right.
Cunningham versus Brown in 1924.
Third
Yeah.
presumption relates to value, and that is that when a fraudster makes transfers to investors in excess of their original investment,
Yes.
the false profits,
Yes.
that is not for value because there's no enforceable obligation to pay them those false profits in the first place.
Now, some courts, and all of these presumptions enjoy currently fairly wide adoption, I think. Notably, though, there have been some recent cases, a very notable case not that long ago out of the Minnesota Supreme Court, the Finn case, that say not so fast. Tell me about that
Well,
view.
so the Finn case is a long opinion, but in a nutshell,
It
the
is,
court
yeah.
said that there's nothing in the statutory text, and there it was looking at the UFTA,
Yes.
From Fraudulent Transfers Act, that provides for the Ponzi presumptions. And so the court found that the Ponzi presumptions would not apply. For example, the court's looking at the badges of fraud in the
Yes.
UFTA. Doesn't say anything about Ponzi scheme or that the existence of a Ponzi scheme leads to an actual intent presumption, and so the court rejected it.
Well, which do you think is, I mean, is it justifiable for courts to keep invoking these presumptions, or should they do what the Finn court said and say, we need actual evidence to prove elements of a cause of action as you do in litigation generally?
Well, so let me confess, I represent trustees normally, so my view
That's okay.
you probably predict, but I disagree with Finn. I think that there was a false premise sort of underlying that entire opinion. The court there viewed Ponzi presumptions as being final and conclusive, not rebuttable. And when you look at the opinion, that seems to have been motivating the court each time it looked at one of the Ponzi presumptions. For example, the court looks at the badges of fraud, the
Yes.
enumerated list, and the statute itself says that no one of those badges is conclusive. And
Right.
so the court says, well, then how can a badge that's not even in the list be conclusive? But the error there is that the Ponzi presumption is not conclusive. It's
Sort
rebuttable.
of setting up a straw man and
It's
then knocking
just
it
like
down. Yeah.
it's just like when courts presume if there's one or two or three of the badges of fraud, two or three normally, they'll presume actual intent. Same kind of presumption that's rebuttable. Courts do it all the time, and so I disagree with Finn. I would note that the author of that opinion was actually my study partner back in law school.
I did not know that.
Yes, and so we
That was
did-
not a setup. I was,
we actually disagreed quite a bit then, and we still do today. But he's obviously
still
a
wrong,
very
huh?
smart person. Yes.
It's still wrong. So, what's notable, and the reason, obviously, that Bill Rochelle included the Pergament case in the Daily Wire, and the reason we're talking about it, is even if, however one comes out on the legitimacy and utility of Ponzi scheme presumptions, it's a fairly dramatic move to say we're going to claw back from transferees, people who get money from the fraudster, who had no idea, had no participation, they hadn't invested. It's not like they had money with Bernie or anything. It's like they didn't have money with this guy. Just got paid by him. What, and of course, I mean, the casinos was saying this is just like the grocery store. I mean, like if you're going to go down this line, say, well, it's in furtherance of the scheme because even fraudsters get hungry, and if they don't eat, they'll get weak and not be able to carry out their fraudulent scheme. And so, when they buy food, they're going to be so grocery store, give it back. I mean, is Pergament something we should really be worried about? I recognize you have your trustee concerns, but
Trying to be objective, I
Yes.
do agree with what Pergament did. So the important limitation there is that the transfer has to be in furtherance of the scheme. And the reasoning is that the Ponzi schemer, by running the scheme in the first place, is intending to defraud creditors, namely the investors. But if the Ponzi schemer is making other transfers that are designed to prop up, perpetuate, further that scheme, it's reasonable to infer and draw a rebuttable presumption that those transfers are likewise with intent to defraud creditors. So I do agree with the Pergament court's reasoning. You point out the grocery store example, which the casino in Pergament kept
He
trying
did.
to compare itself to a grocery store. And I wondered, where did that comparison come from? There's actually a case, and you probably know this, but there's a case from a few years ago in the Southern District of Florida where a trustee sued the grocery store because the Ponzi schemer went in there every weekend and bought his groceries there.
exactly.
But the court
Even
there found
Ponzi schemers get hungry.
they do. They need to stay well fed. But the court there found that those transfers weren't in furtherance of the scheme. There's not a lot of analysis in the opinion, but I suspect that there wasn't a close enough nexus between simply eating food and really furthering the scheme itself.
And of course, something that then we immediately look to, and which will be relevant to the constructive fraud issues, which we'll talk about in just a moment with Judge Harner, is the facts that there's a possible defense here. I mean, if you say, well, you can't come in and gamble, I mean, you got value. We didn't know anything about the scheme. You go to the grocery store, I say, I want a loaf of bread. Well, a loaf of bread's $2. I mean, and so we are going to have a good defense under 548C, right? We don't know anything's going on. There's value. I mean, you had a chance to win. I mean, a lot of cases dealing with like gambling losses, and they usually say, well, I mean, you have to look at value ex ante, and it's like you had a chance to win, aside from the entertainment value. The court, though, what does the court do with that impurgament?
So the court looks at the good faith defense and finds that, at least for purposes of 548, the trustee has adequately pled enough to survive the defense. The defense is normally very fact intensive.
So it's not a good 12b6 play.
It's not going to be a 12b6 motion. Could
Yeah.
be summary judgment, but the court will want to dig in later once there's actually some discovery that's been taken to determine whether good faith defense does apply, namely the good faith element of the defense rather than
So the
value.
significance, though, for someone like the casino is there's sort of nothing they can do to get the case dismissed. Ponzi scheme presumptions get the potential actual fraud, and then the defense is going to be fact intensive. It's not subject to the motion to dismiss. Now, Michelle, the constructive fraud claims, though, which were brought under New York law, came out the other way. There, the casino did win on 12b6. Why?
They did, and as you know, it's just under New York law. They didn't bring a 548 constructive fraud claim, which we can talk about in a moment. But so under New York law, right, so New York debtor-creditor law, sections 273 and 275 talk about transfers that make someone insolvent or while they are insolvent, that aren't given for fair consideration. And it's really this term fair consideration that helps the casino here, because under the code...
Which came from the old UFCA.
Correct.
Right, which
not
I
the
always tell my
UFTA.
students, you only have to still worry about because New York has it. Right?
Exactly.
Yeah.
And you're right, it's statutory. So under
Yeah.
272 of the New York
But
Code,
what do they say fair consideration means in New York law?
so it includes this component of good faith
Of whom?
of the recipient.
Yes.
But it's the trustee's burden. So
Right.
unlike the affirmative defense that Eric was talking about, that at the 12b6 stage really wasn't before the court in a way the court felt comfortable resolving it. On the 12b6 claim with respect to the constructive fraud under New York law, the court said that's one of the trustee's elements that he has to prove.
And so it's not at the defense stage, it's at the liability stage. Is there constructive fraud? And so what was the trustee's failure in purgament with regard to that?
So the trustee was basically trying to argue that the casino had to know about the fraud, and that because it had to know, there was no good faith. And apparently under New York law, good faith means something a little bit different in the constructive fraud context. You actually have to be involved in the fraud, it appears. If you just know about it, but you're a creditor and
interesting.
you're entitled to payment, you're still taking the money in good faith. And, you know, the court talks a lot about how New York distinguishes its constructive fraudulent conveyance claims from preference claims.
Right.
And they're not one and the same.
Right.
If, you know, someone's just paying a creditor and maybe it's
Right.
from fraudulent sources, and the creditor may know it's from fraudulent sources, but they're entitled to that money,
Right.
that's not a constructive fraud claim that will be successful under New York law.
So what if this same kind of facts, if this had gone under 548, or even if we went 544B in a UFTA or UVTA jurisdiction, would the casino be clearly a winner here because the trustee had not pled that they were a sort of knowing active participant in the fraud, which was the defect they said in purgament? Let's say they had brought it under 548, brought constructive fraud, or they brought it under, if it was in a state that had the UFTA, where you don't have that odd quirk that as part of your constructive fraud claim, not as a defense, part of the claim, you have to show the transferee was sort of a knowing participant in the fraud. What do you think would happen?
So, Eric, you may disagree, and Professor Tabb, you may disagree, but I actually found the New York law and the way the statute's written probably a little bit beneficial to the trustee here, because it gave him a potential claim against the casino, where I think under 548 and a constructive fraud claim there, what we're looking for, right, is a transfer not made for reasonably equivalent value. You know, and you had the parties here, you know, agreeing. There's undisputed entertainment value to gambling. I mean, that was a quote from...
As well as the fact, before you place the bet, lots of cases said, right, before you place the
Right.
bet, you had a chance to win.
Right. So, you know, if you've got reasonably equivalent value, I think...
Game's over.
Game's over. Where at least under the New York statute and the
You
old
have the
UPCA,
opportunity to probe the bona fides of the
Absolutely.
transferee.
So in a weird twist, it could have worked to the trustee's benefit here, perhaps if he had a little bit more. You know, it is interesting. The casino seemed to fell quite a bit in its checks on this particular debtor. You know, reissuing his credit and things like that along the way. But
Oh,
the
for
court-
sure. Well, I
court didn't
think
quite buy into
we
that.
will definitely see purgament being used a lot as we go forward in Ponzi cases. Well, staying in the world of fraudulent transfers and issues, recent case out of bankruptcy court in the Middle District of Florida, Judge Colton in the Taylor Bean and Whitaker Mortgage Company massive fraud that blew up, extended the mere conduit defense under 550A for the initial transferee to recipients other than banks. So, Eric, get us going again here with the this. First, tell us what is the mere conduit defense? Why did courts develop it? I mean, what's it an exception to? What do you have to show?
Right.
Tell our viewers what this is about.
So the applicable code provision is 550A1. And the concern there is that 550A1, dealing with the liability of the initial transferee to an avoided transfer, is strict liability. There's no exception there built into A1 for good faith. On the other hand, a subsequent transferee under 550A2 does have a good faith defense. And so the concern is that it's possible that the initial transferee, like maybe a bank, who may be just a mere conduit, has greater liability than the ultimate recipient of the fraudulent
They have no
transfers
defenses.
under A2. And so
They know
courts have-
nothing about the fraud. They're just
That's
carried
right.
out.
And so courts have created this mere conduit.
What do you have
defense.
to show to establish if you're being targeted on and as the initial transferee, and you're like, whoa, no, I'm a mere conduit.
There are two things. You have to show that you don't have legal control, which generally means, and by the way, this test varies by circuit, but at least in this case, you don't have legal control, meaning you don't have the right to put those funds to your own uses. And then two, that you received the transfer for value and that you were just an innocent participant in the fraudulent transfer.
And so in this case, and as you said, this normally comes up to protect banks because obviously fraudsters, funnel money through their banks. The banks are just like you have an account there. I mean, you're supposed to honor transfers out of the accounts that the account holder says. Judge Colton, interestingly, extended that to someone not a bank. So there's some features of the bank. What exactly was going on in the Taylor Bean and Whitaker case? What the factual setting and sort of what was judge's reasoning on why this was an appropriate extension of mere conduit?
So the Taylor Bean case arose out of a massive fraud. I think the case calls it, quote, a great big fraud.
They did. I like that. A great big fraud.
Taylor Bean was one of the country's largest mortgage lenders at one point, and it collapsed following an FBI raid in 2009. There was a Chapter 11 bankruptcy. Claims were put into a trust to be pursued for the benefit of creditors, and so the trustee pursued a claim against ADP, which had been the payroll service provider for the company, for Taylor Bean. The trustee's argument was that $34 million that had been transferred and sort of funneled through ADP to pay employees over a few-year period, that was all a fraudulent transfer, and ADP had liability as a fraudulent transferee.
Under 550A1.
Under 550A1. And so ADP argued mere conduit defense, right? The judge found that the defense did apply to ADP. Again, as I said, there are two elements to the defense, legal control and good faith. Applying the first element, Judge Colton found that ADP did not have legal control. And there she really drew an analogy to a deposit bank and found that ADP in many ways acted like a deposit bank by receiving these funds and following the instructions of its customer.
Pursuant to their agreements they had.
Pursuant to a number of agreements, and found that ADP always followed those instructions and therefore didn't have legal control. Interestingly, Judge Colton noted that it's not a perfect comparison. There were some differences, but she said that she had to apply the mere conduit defense, I think she said, in a flexible, pragmatic, and equitable way to determine whether ADP is really an initial transferee. She found it wasn't. No legal control. And then on the good faith element, again, she said it's undisputed. There's no actual knowledge here on ADP's part.
So it's just the inquiry notice.
It's all inquiry notice, and she looked at each of the alleged facts that should have put ADP on inquiry notice and found that none of them put ADP on notice.
And so, Judge Harner, what was your reaction to this case when you looked at it? I mean, you've been a professor, you now sit on the bench. I mean, like, A, just thinking about the mere conduit defense in general, and B, thinking about the application, the continued extension of it. Is this a faithful application of the code? I mean, is this just courts making stuff up? I mean, how do you react to this? Not to put you on the spot.
So I think in a little, in a little way, it's similar to the gap filling we were talking about earlier. I think the 11th Circuit, where the mere conduit exception really developed in a robust way, saw a potential gap that it felt it needed to fill in. And I think Judge Colton does an excellent job analyzing the elements of the mere conduit defense, so that if you're inclined to invoke it, I think she's very faithful to it and does so in a pragmatic and equitable way, thinking about the purpose of fraudulent conveyance law and the role that ADP played here, not only for this debtor, but probably thousands of other companies that could potentially fall into this bucket. Now, whether or not the mere conduit exception should continue to exist, given the language of the statute and the apparent per se liability for that initial transferee is a different question. And
It
you know,
is.
the Supreme Court somewhat dodged that, last term in the merit decision,
did.
focusing, on the transfer that was challenged as opposed to
Right.
the exception.
Right.
So perhaps we'll see more on that later down the road.
Well, I think with the extension like this, there's going to be a conflict, and it'll come up. Well, it's always fun to talk about fraudulent transfers. It's always fun to talk about repoint cars, but there are other interesting things. One of the biggest protections for the home mortgage lending industry is they've done a good job lobbying, and as I'm sure our viewers all know, in both Chapters 11 and Chapter 13, there's an anti-modification rule for home mortgage. Turns out that it's not quite that simple in a lot of cases. If you have a situation where the property, there's a mixed use. In other words, it is partly used as the debtor's primary residence. It's my home. But also, let's say I thought I'd start moonlighting, so I mortgaged my home, but I thought I'll open, Charles's nail salon, start doing some manis and pedis and stuff. Or, the case we have before us, the Lister case. A couple had been running a child care business for over 20 years on the premises. Well, the question that comes up, there's actually two sets of questions, is firstly, if you have a mixed use, that is, it's partly your residence, but partly some other stuff, a business or something like that, is the anti-modification rule applicable or not? And then secondly, also, a very important question, if you think about it transactionally from the perspective of the mortgage lenders, when do we measure that? Is it when you made the original loan? They do their due diligence and find out, so are you also running, a nail salon or something here? Or is it at the date of the petition? So we had this case, I said, in Lister, the couple, no question, they'd had been running a child care business for many, many years there. In their plan, of course, they wanted to modify. We always want to modify that home mortgage. Judge Buchanan first has to look at the three major approaches for dealing with the mixed-use cases. That is, does the no modification rule apply or not? Michelle, what are those approaches and sort of how are they justified? How do courts reason through those?
So as you say, there's basically three approaches, two bright line approaches, believe it or not, and then one kind of case by case.
That's the kind of thing, that drives our law students crazy.
Yes.
It's like, there's a bright line approach that says A, there's a bright line that says not A. Well, what?
Right. So the first bright line approach, I think, probably is a little bit in the majority. It's the bright line only test, which means that the security interest has to be in real estate that is the debtor's principal resident and nothing else.
And nothing else.
And both the third
So if that
circuit-
were the facts, Lister would have come out the other way.
Exactly.
Okay.
Right. So both the Third Circuit and First Circuit followed this approach, and the Third Circuit does so based on its reading of the text of the statute. It says is means is, and if you think about the definition of is and its origins, right, it's typically to identify or to say something is equal. So they say is the debtor's principal's residence is exclusive. It has to be that and that alone. The First Circuit doesn't go so textual in its analysis, looks more to the legislative
Didn't
history.
find that much weight to that little two-letter word.
No, but they turn to legislative history, and if you look at the legislative history, there's actually a great Fifth Circuit case back from the 80s, the Grubbs decision, that pulls together all the legislative history on 1322. And there's not a whole lot there. There's a lot of testimony from witnesses and then changes that the Senate and House made to the respective versions. But there's a lot of inferences that we draw. So courts choose to rely on that sometimes, and that's how the First Circuit's gotten to the bright line only test. Then there's the bright line includes test, and it finds that there's no exclusionary language in 1322b2. So as long as some portion of the real estate acts as the debtor's principal's residence.
If that's where the debtor lays her head at night, sorry, mortgage lender.
Anti-modification, right? So in mixed-use cases, the includes approach captures that property and applies the anti-modification. And then
So it brings it in, yeah, okay.
it brings it in.
Yes.
And so, bright line only has to be only the residence. Bright line includes, if it's mixed use, it's within.
Then it's within, right.
And so then you have the case by case, which basically says we're going to consider the totality of the circumstances. What was intended at the time of the
Gotta love
loan? Was it commercial?
yeah.
Was it residential? What were the expectations of the parties? Yes. And right, I mean,
Which is impossible to apply and gives no certainty.
and that's the critique of it, right?
Right.
Courts that haven't followed it say there's no certainty there. I want to choose one bright line.
So which way did Judge Buchanan go?
She goes with the mixed use is within anti-modification. So she takes the bright line includes approach
Right.
and says if the debtor resides there, no matter what else the property is used for, you can't modify.
And so on these facts, it was not able to be modified because the debtors live there. So it's
Correct. And there
very
were-
protective
There were
of the
multiple
mortgage
uses
lender.
of the property,
Many
right? She
uses.
was renting part of it. She
Yes.
was operating a daycare. She was residing there.
Yeah.
There were apparently multiple
Yes.
tracks. So lots of ways
But
to
that's
get out
very,
of,
very protective then of the mortgage lender.
of the mortgage lender.
Absolutely.
Exactly.
Now, that then leaves the question, though, of when do you make the call? In their courts, I mean, some have said, well, the thing that makes the most sense is when you executed the mortgage, because that's the only thing the lender actually had any control over.
Right.
They could do their due diligence, whatever. Other courts, though, take this petition date approach, say, well, what is it on the date of the petition? And others go warm fuzzy again.
Right.
Let's look at everything. So which is the majority view, and what's the justification for that? And then what did Judge Buchanan hold?
So, I think in part, courts tend to follow the date they choose based on which bright line they choose. Because if you think about it, the
Right.
bright line only test is subject to manipulation. And that's one of the critiques.
Explain.
So if you say it has to be used only for the debtor's residence to come within the modification protection, a debtor at the time of extending the loan could get a mortgage for a piece of property that she says she's only going to use for her principal residence. Creditor's feeling pretty good about that. And then subsequent to executing the documents, she decides she's going to operate a mani-pedi salon or a daycare. All of a sudden it's mixed use and may, in some jurisdictions, fall out of the anti-modification protection. So courts following the bright line only tend, I think, to gravitate towards the date of the loan.
Because that's all they can control.
That's all they can control. So if the lender thought they
Right.
were getting a residential loan, then they should be protected, right?
Okay.
That seems to make sense. Those following the bright line includes test, as Judge Buchanan did, tend to go with the petition date. And Judge Buchanan does a nice job of explaining her reasoning. She said if you look at the language of 1322b2, it talks about the secured creditor's claim. We think of claims being in the present tense under 1015, and so I'm going to use the petition date. So she couples...
We only have a claim when there's a bankruptcy petition.
Exactly. So she
Yeah.
couples the petition date with the includes approach. And then as you say, the case-by-case warm fuzzy test somewhat goes with the hybrid test, which again is fact-based on the circumstances as to what the courts believe would be most appropriate under the facts of the case.
Well, this is clearly going to continue. It's fascinating to me that this issue has persisted from the early days of the code. There's a number of issues like that. One would have thought, if you looked in 1982, that this will surely get resolved by 2018, but no, we are not yet resolved.
Well, it's two
So
things that we really care about, right? People's homes and
Yeah.
the mortgage industry, because
absolutely.
it's important. It's an important
Yeah.
social,
Yeah.
economic engine.
Absolutely.
And certainty is important.
Yeah.
So.
Well, let's consider another very important business issue, which has to do with executory contracts, the ever troubling and fascinating, crazy world of executory contracts. Recent case out of the Fifth Circuit, the Provider Meds case decided by the Fifth Circuit October 29th, discussed in Rochelle's Daily Wire October 31st, involves the issue of what happens. It was a case that started in 11, then converted to 7. There was a sale of a lot of assets, which included maybe some technology license, except for the fact nothing happened within the first 60 days after conversion. So, Eric, we had this small little issue that 365D inconveniently says that if in a 7 in conversion date, if nothing is done within 60 days, deemed rejected. So you have this hopeful purchaser, but then the technology licensor saying you're out because nothing happened. So talk about what exactly was going on in that case and sort of how the issue arose, and then what the Fifth Circuit said about 365D and what we do. Because the problem was, we can understand it if we know about the, but like this was kind of an unknown and unscheduled executory contract. They sort of discovered that fact, said, "Whoa, look at this."
That's right. So you've summarized many of the facts, but essentially this was a Chapter 11 originally, where the debtor had failed to schedule a patent license. It doesn't appear that the debtor did that intentionally, just for whatever reason it wasn't scheduled. Case later converted to Chapter 7, and the trustee, because he didn't know about the patent license because it wasn't scheduled, did nothing to assume it within the 60-day period of 365D1. But after that 60 days had expired, the trustee sold the estate's assets to someone else, this company called RPD, and the sale agreement arguably included the patent license within the broad definitions of the agreement. About a year later after the sale, a dispute arose between RPD and the actual licensor of the patent about who owned it. RPD argued that it had purchased it under the sale agreement, of course, and the patent licensor said, wait a second, it wasn't assumed within 60 days, it's deemed rejected under 365D1. So the Fifth Circuit looked at that, and ultimately Judge Higginbotham ruled that it was deemed rejected. He looked at the case law on this issue, recognized that there's sparse case law on this, and there's some different results. He points to a line of decisions where when a debtor has intentionally concealed a contract like that, courts have found it's not deemed rejected in that instance.
Sort of an equitable exception almost.
That's right, but he said the facts aren't here for that. So,
and it would perhaps be an interesting question whether after Law v. Siegel that could even still stand. But anyway, that's for another day.
So Judge Higginbotham ultimately looked to a decision from the Ninth Circuit, the Cheadle decision from back in 1985, a decision under the former Bankruptcy Act, where the Ninth Circuit said, well, wait a second, a trustee under the Bankruptcy Act has this affirmative duty to go out and investigate for unscheduled contracts. And so if the trustee has failed to identify a contract and presumably failed to investigate, there's a conclusive presumption that it's deemed rejected. Judge Higginbotham said, well, that makes sense, and that reasoning should apply here because under the code, there's a similar obligation in Section 704 for a trustee, and so if he fails to take action, it's deemed rejected. And that was the ruling by the court.
So, last thought on this case before we talk about an interesting rules problem in the dischargeability context. A purchaser like RPD, is there anything they can do? I mean, tough outcome for them.
Yeah, it's hard to do something when you don't even know about it, right?
Right.
But, I guess there are three things. One, RPD could try to buy assets before the 60-day period is run to make sure that contracts are
If there's some
identified.
working contract,
You're going to get it. If it's out
it.
there, it's assumed, it's assigned, I've bought it. If you're not able to close the deal within 60 days, maybe you move to extend that 60-day period for cause.
And maybe that's the safest thing to do.
Sure.
Because because then you have a blanket assumption order when you get around to the
You
sale.
have more time. And then I guess the third thing is you could try to build in some sort of contractual protection for yourself, like maybe a holdback and an adjustment to the purchase price. If within a certain period of time, maybe another 6 months or so, we identify some contract that wasn't known but should have been assumed within that 60-day period, we're going to adjust the purchase price to account for that.
Well, and that latter approach would encourage Chapter 7 trustees to seek an extension
That's true.
of
Absolutely.
the deadline if they know they might sell the assets because they're going to want to get as much value as they can.
And speaking of Chapter 7 trustees extending deadlines,
Yes.
we have a case, very interesting problem, interesting at least to bankruptcy professionals, and debtors, the Oliva case, case out of the Northern District of Illinois, discussed in Rochelle's wire on October 30th. Here's the basic play. As we all know, the trustee does not have standing to file an objection to the dischargeability of a particular debt under 523A. The debtor can, of course, usually the creditor says I was defrauded or whatever, they would. Trustee clearly under Rule 4007A and under the statute does not have standing. What happened in the Oliva case, and it's happened in a number of cases, is trustee files sort of a blanket motion to extend the dischargeability deadline for filing dischargeability complaints under 4007C. And of course, what happens then? Some creditor past the original deadline, but before the extended deadline, files dischargeability objection. Debtor's like, hey, sorry, too late. There are a couple views on this in the courts. Circuit split. What's the split, and how does this court come out?
So actually, where I sit in the Fourth Circuit has a case, the Farmers case, where they looked at 727 discharge, 523 discharge, and the respective rules, and they said 4004B, right, 4004B that governs 727 uses this term party in interest, but it's a case where both the creditor and the trustee can object to the general discharge
Right.
under 727. So the trustee is a party in interest under that section and that rule. But then they contrasted that with
Right.
523 and 4007C and said
Right.
because the trustee can't bring the complaint, the trustee's not a party in interest for those purposes, has no economic interest in the action, can't bring it. So under that position, the creditor
So the debtor
in your
would
scenario,
win in a case like that. They
Exactly.
said, sorry, trustee, you don't have standing.
Right, Sixth Circuit in the Brady case went the opposite way, said, we think of party of interest broadly, this isn't a substantive claim, this is procedural. If the Rules Committee wants to give all parties in interest the opportunity to extend the deadline, even if they can't bring the substantive claim, we're going to allow it. Our case, the Oliva,
I'm going to go with Oliva,
Oliva?
but only because there was an old baseball player, Tony Oliva, for the Minnesota Twins in the 60s,
that
and he was
reasoning.
pronounced Oliva.
All right, we're going with Oliva.
We'll go with that.
We'll go with that. I think that's decisive.
And
Yeah.
so the court in Oliva follows the Sixth Circuit and says trustees are party in interest, and also notes, and I think the Sixth Circuit does this
So
as
they
well.
basically went off on contrasting Rule 4007A on who can file a complaint, 4007, which says debtor or creditors,
Right.
and 4007C, which says party in interest, and said, a trustee's a party in interest. Come on.
Well, and it's interesting because
Yeah.
I'm under the Fourth Circuit economic interest test.
Right.
And the Sixth Circuit and the Oliva case says, trustee has an economic interest, arguably, even in the non-dischargeability context
Yeah.
of 523, because that creditor still shares in pro rata distributions
Right.
from the estate. So it was interesting to see the critique of the circuit decisions in the Oliva case.
There was also just lurking in that, there was a service of process
Yeah.
issue. We don't really have enough time to deal with that, but the debtor also lost on that and said, you're not entitled to personal service. Just got it electronic through your lawyer. Well, another, time is running low. We have one more consumer type case, which is, I hate to, when you have decisions that bother you and then they just keep getting extended, it just bothers you all the more. So we're dealing with retirement funds or not retirement funds, things like 401ks and IRAs, which many people might think are retirement funds, but not so for Brian Lehrbachen, who, according to the 8th Circuit BAP, Brian, in marital property settlement, was allocated the wife's 401k and her IRA, gets into bankruptcy and says, sorry, it's not exempt. Here's this little decision called Clark v. Ramaker. So tell us about Clark and tell us why Brian had to say goodbye to his, what he thought was the 401k and the IRA that he had gotten.
So very quickly, the Clark decision, Justice Sotomayor wrote for the court, focused on an inheritance that the daughter had received from her mother, about $400,000. Subsequent to that time, the daughter and her husband filed bankruptcy, about $300,000 left in the IRA at the that point of the filing, the daughter had elected the installment
Right.
payments from the IRA. They note the $300,000 IRA as exempt. Trustee, as you can imagine, in the bankruptcy case, not too happy with exempting $300,000 in assets, so objects. And when it gets up to the Supreme Court, Justice Sotomayor takes a very methodical look at what it means to be retirement funds, which is the applicable language
Right.
in the exemption
Right.
statute under 522.
Right.
And she said the code doesn't define retirement funds, so we're going to look to plain meaning. Funds means money set aside. Retirement means when you stop working. So retirement funds basically are monies set aside for when you stop working. An inherited IRA doesn't fall into
Right.
that. So she also goes into the differences between inherited IRA and regular IRAs. But in our case, Brian is stuck with that decision. And because his IRA was granted to him as part of a property settlement in a divorce, the court said you weren't setting that money aside for your retirement, not retirement funds, not exempt.
And it sort of goes back and just continues the problem from Clark. Is sort of like retirement funds in whose hands,
Right.
right? And consistent with Clark, it says, well, Brian, it was your wife's retirement funds, but it's not retirement funds as to you. We don't have any more time today. I do want to just note for our viewers that case we talked about last month in Ion Bankruptcy, the Tempnology case, Supreme Court has granted cert, as we had projected that they would. So we will, at some point, find out what happens to a trademark license that's rejected, whether the licensee is just out of luck or not. At this point, though, I want to thank you, Judge Harner. I want to thank you, Eric, for your valuable insights. It's been a very interesting program with you. I want to thank our audience for watching yet again. There are many sessions, many seasons, 4 seasons of Ion Bankruptcy episodes that are online on demand. Next month, on December 27th, we'll be having Judge Ashley Chan from the Eastern District of Pennsylvania and Russell Sieberglund from Richards, Layton, and Finger in Wilmington. Until then, this is Charles Tabb reminding you to elevate your understanding and keep your eye on bankruptcy. So thank you both again.
Thank you.
Appreciate it.